Well, the province's doctors govern themselves via the College of Physicians and Surgeons of Ontario. The college is there to protect the public and investigates patient complaints against doctors and decides on disciplinary actions. Joining us now for more on this role and its effectiveness, Dr. Mark Gable, president of the College of Physicians and Surgeons of Ontario. Julia Martin, health and professional regulatory lawyer with her own practice in Ottawa. Michael Decter, board chair of Patients Canada and former deputy minister of health under Premier Bob Rae. And Jeremy Petch, opinions editor at healthydebate.ca. Welcome to all four of you. Thank you for joining us around the table. I want to start with a case that's been making news. This is the case of pediatrician Dr. Kunwar Raj Singh. I want to read some stuff about what's been going on in this case. Back in 1991, 6 counts of indecent assault he was charged with and 10 counts of sexual assault under the criminal code. He was suspended, sentence of 2 years probation was what his punishment was. He was found guilty at the time of professional misconduct by the College of Physicians and Surgeons and suspended at that time for 6 months. A year later, he applied to practice medicine in Trinidad and Tobago using a forged document, and the CPSO, the college, later issued a 6-month suspension. Then about a decade later, in 2003, Dr. Singh agreed to the restriction of having a female chaperone being present when he is seeing female patients. And then last year, the CPSO updated the restriction preventing Singh from treating anyone over the age of 18. That's from the CPSO's own file. Mark Gable, let me start with you, Doctor. Sure. How is it that Dr. Singh continues to practice medicine?
First off, this is a case from 1991 under the old act. There's a new act called the RHPA with very different penalties, very different directions on how we function. But be that as it may, that was a panel at that time who said this was the proper sentence. It's a panel that's independent of the college, independent of the doctor, public members, and physicians who serve that. And so that was what they considered the proper penalty at that time, 1991. Since then, obviously, things have happened. And the present thing, the last restriction that went on to his record is what's called an undertaking. Means that he voluntarily agreed to certain restrictions on his practice. I do not know, nor are we allowed to publish why someone agrees to that. I do not know what preceded it, and what we do know is we inform the public this is his restrictions.
Okay. I want to come back to you on that,
Sure.
But why as a member of the public, I don't know and what kind of faith I'm supposed to have in all of this. But Michael, let me come to you. How is this doctor, when you see this case, it's one example, there are others we could use of what's been going on. How is this guy still practicing medicine? Is that okay in Ontario?
Well, I don't think it is, and I don't think the public thinks it is. I read all of the published cases for the last 3 years in preparation for coming on, which sounds like a huge amount of work, but it isn't, because the college only publishes 2% of the cases they hear. And what was striking to me about them was they were almost all repeat offenders. That is, there would be an initial finding and a restriction, usually sent off to a course, a small fine, second time round, some kind of restriction. And then in some of the cases, and this is far from the most spectacular one, I mean, there's one where a patient dies from liposuction. The college finds, and I think I'm quoting them, that the doctor was not qualified to perform liposuction, and there was a death, and there was really extreme language in a 377-page college decision. And then, you would think, I read it, I thought this doctor will be out of practice, but no. 4 years later, there's another case against the same doctor because the license has been restricted. I think we are still in an era where the college is trying to salvage every doctor, and where the public are saying, what about the patients? What about further damage done by these bad apple doctors, of whom, fortunately, there aren't very many, but they manage to do a lot of damage because they tend to continue. And I'm not the psychiatrist here, but I think people who are abusive, and we see this in public figures, there isn't one case. It isn't as though the one woman came forward about Bill Cosby, one woman came forward about Jian Ghomeshi. There are patterns, and the behavior seems to be repetitive. And so I think the public is at a point saying, if someone's behaved badly, surely they should be out of practice.
Okay, so you're talking, I know, Mark, you want to hop in here. Let me come to Mark, and then I'll come out to this side of the table.
I just want to say that, Michael, in all due respect, you say 2%. What you're talking about, what you were reading, was those who were referred to discipline, which under the present transparency, everything that happens in discipline is published. Those are the 3% of the doctors who are referred from the complaints department. Of all the complaints they see, there are other solutions. And this is very simply that those were done, they were done by a panel which could be appealed to regular courts. And whether you agree or disagree with the decision, this was done to protect the public. That was their first job. Their second job was to punish the doctor, but not necessarily to kill every doctor that appears before them. And their third job was to see if there was any possibility of rehabilitation. And I think that's a reasonable set.
We're going to talk about perception and put that in the context, but just let me come to this side of the table, because I want to get Julia and Jeremy to weigh on this. When you hear a case of the one I outlined at the beginning, or the one that Dr. Dechter, that Michael Dechter brought up, what goes through your mind?
Well, what goes through my mind when I hear about those cases, and when I hear these two gentlemen speaking about this, is it's all well and good to say we need to get rid of the bad apples, but there's a process. And yes, patients shouldn't be subjected to dangerous physicians. We all agree on that. Everyone in this room agrees on that. The problem is you don't try people in the press. The Toronto Star doesn't get to decide if a physician is guilty of professional misconduct. You've got to send the physician through the proper process. The complaints committee, it's called the ICRC, refers allegations to the discipline committee when they believe that they have a reasonable chance of conviction or a finding of a guilty finding. And then there's a hearing, and the hearing is a panel that is independent of the college itself. And it's got 2 members appointed by the Lieutenant Governor, and they're members of the public. So they hear it. It's like a trial. And when that trial is done, they use the laws that the government enacted for them to follow, and they make a decision, and we live with those decisions. They're probably not always right. I get that.
Except for the distinction of comparing it to a trial, is that a trial is held in open court.
And so are these disciplinary hearings.
The last one.
If I could, you said the panel is made up of 2 citizen members. That's not the whole panel.
Two of whom, the Lieutenant Governor and Council appointees, are members of the public.
But the majority of every panel is physicians.
No, there are 5 mandatory, there's a minimum of 3 and a maximum of 5, and 2 must be appointees, public appointees. Therefore, when the quorum is 3, you can get panels where there's only 1 physician on the panel.
Well, I must say in all the cases I read, I may have missed a couple, but they all seem to be 3 physicians and 2 non-physicians.
Well, they aim for that. They certainly...
Yeah, that's where we aim, and if you were looking at that, Michael, you'll see a whole bunch of cases with only 4 people there, 2 public, 2 physicians. That's common as well. So it's, but it is basically an independent panel with public representation.
Okay.
I think it's really important to say that there's real value in having physician members on these panels, right? Whether it's a disciplinary hearing for a medical error or for some other issue, physicians have the knowledge of a very specialized scientific literature, and they've been in the trenches delivering care. They understand the kinds of dilemmas that physicians face, and it's important to have that representation as part of the disciplinary process so that there's an understanding of the kinds of issues that are going on. And you know, you do not want physicians being the only ones, so it's essential we have public representation to have that balancing factor so that if physicians are we don't become overly sympathetic to their colleagues or try and protect their colleagues. But the idea that we wouldn't want the physicians there and to have an important voice, I think would be wrong.
Let's be careful in what happens when you argue for self-regulation and it doesn't work out in the court of public opinion.
I want to take a step back, because you all know this intimately, but as a member of the public, okay, I go to a doctor. I just want to, Mark, for you to walk me through this process. I go to a doctor. Something happens, you know, while I'm seeing that doctor. I say, I've been assaulted by that doctor. What happens? I go to the college, I say, this happens, I go to, how does the process work?
The process works that you go to the college, as you said. There is someone who will interview you. You will be given a support person as well to help you through the process. That complaint goes to the ICRC, as Julia mentioned, a complaint committee. The doctor gets to respond to the complaint. The committee looks at evidence. They may order a full investigation, which means they have the rights of a public inquiry, which means they can get charts, they can get any information they want from anyone. The panel then sits, and again, this is a panel of public members as well as physicians knowledgeable about the field and interest. And they look and decide, can they get, let's say in your situation that you've mentioned, is it possible to get a possibility of a conviction? And based on both your vulnerability and a lot of other things, there may be negotiations, but it will be referred to discipline. And once it's referred to discipline, no one can appeal that any further until discipline hears it. And then it goes to a full hearing, which are public, and a decision will be made by that panel, which is appealable to the courts. I would say that in the last 6 years, we've had 2 cases that have been returned to us by the courts. All the rest, the courts have upheld us in our decisions, both on legal issues and on factual issues. The penalty that would come out, let's say the person was convicted.
Convicted, you mean by the college? You're not talking about the court?
No, by our discipline
I just want to make that distinction,
yes. Was to say the allegations were true. They then have a penalty hearing, and they're informed by common law, by the Regulated Health Professions Act as to what they must or can do, and as in any court by previous decisions. And both sides give presentations, and they do, again, as I mentioned earlier, the first thing is, are you protecting the public? Now, that's an issue of what do you mean by protecting the public? 2, to punish, I think would be a good term. 3, to inform the profession what are the standards. And 4, to think about rehabilitation. And some, you can think about that.
What does that mean?
What does it mean? It means that I think that if someone has had competency problems, is there a possibility to change that? If there's been behavioral problems, is there a possibility with both education, with courses, with continuous supervision, to get that person back into practice? The idea isn't just to say, you did something bad, go away forever. But maybe there's some hope.
Why not? Why isn't that the idea?
I think that, I look back and say, mercy is part of this world as well. And also to provide for this physician and for the patients he or she has been seeing. An issue has arisen. That doesn't mean that the person is totally, utterly incompetent. If that were true, they're gone.
But might say that they have very poor judgment.
The question always arises, can judgment be changed? Can someone learn judgment? And if we don't think, from what we've heard in that case, that that person is capable, well, then we're going to have revocation. But again, that is the ultimate penalty, and you want to look around. Just like if there's issues in public of aggression, everyone doesn't go to jail for 25 years. We see whether there's a hope of rehabilitation.
Okay, let me
just weigh in on this because, I heard this 20 years ago when this issue first surfaced as a result of the college commissioning a report that Mary Lou McPhedran did, and rules changed after that somewhat. But let me just come back to you as a patient who's been abused. First of all, you're most likely to have suffered that abuse in a situation where there was no witness. So there's you and the physician.
Sure.
Second, when you make the complaint, you have only your own resources and whatever support in terms of some advice that the college might provide. The physician has resource to the best legal minds in the country. The Canadian Medical Protective Association, CMPA, has, the last time I looked, $2 billion of resources. They have a tradition of litigating every case. That is, they don't settle. Furthermore, and I think this is something not known to most Ontarians, case of Ontario doctors, 90% of their malpractice payments are from the public purse. That is, the government, through the negotiation with the OMA, has agreed over the years to make those insurance payments, 90% of them on behalf of physicians. So you're up against a very, very powerful adversary. First of all, and this is the attitude of the college, continuing one, and you did use the phrase, doctor, capital punishment or final punishment. Doctors aren't being executed. They're at worst losing their licenses. But the other doctors see this as quote-unquote capital punishment. They see it as far too extreme a punishment in most cases. So you know, and the citizen members who sit on these things are appointed by Lieutenant Governor, but they're trained by the college. So two things that Patients Canada feels strongly should happen. Number one, once they're decided, all complaints should be made public. So if the college investigates and they decide Dr. Smith behaved properly, that should be disclosed and it should be put up, because then when some other patient goes to Dr. Smith and has the same experience that you had, they have some basis for coming forward. The second is that the patient or the public representatives should be trained somewhere other than the college itself to make them truly independent. And look, I say this with a great deal of respect for the college and those who've worked there. They have tried, I think, very hard to find a balance, but when one side has enormous resources, and doctors are not without financial resources, and the other side, the abused patient, has very little in the way of resources, it's not a fair fight. And I'll just say this now, in case I don't get time to say it later. In the UK, there were a series of cases like we're seeing in Canada, sexual abuse by doctors. The colleges in England were seen as taking too light a response, too generous a response towards the physicians. There was one horrific case, and it was the end of self-regulation. The government of Tony Blair took away the self-governance of the profession because the public said, you're not doing a good enough job.
You know, the one thing I just have to interrupt, that the conflagration of partial truths with the truth really is upsetting. This is an area where you're talking about the CMPA defending doctors against the poor patient who has no resources. The patient is not the person who prosecutes the case at the college. This is not a civil action we're talking about. This is the prosecutorial resources of a college, which are great, which we spend a hell of a lot of money on. And these are the people who prosecute and deal with the doctor. This is not the civil. We can talk civil another time. We're talking about the college now. We prosecute to the nth degree. We will hire as necessary, and I'm sure you can tell us something about that, Julia.
Yeah, I guess what strikes me from what Michael's saying, I certainly understand his point, but I think that he's not taking into account the processes, right? The college does what the RHPA says it should do. Those are the rules the college follows. It follows its rules. So it establishes committees and it operates its hearings and it bases them on common law, which is other cases that have been decided, and the rules that the legislation provides. And the government passes those laws. So I think, and then when there's an appeal, that goes to the courts. And the courts might think something completely differently. I participated in appeals where the college made one decision and the court said, no, you're not being fair to the member. Because the physician, even if he or she has done something wrong, does have rights. They have a right to be treated fairly, to have any allegations about them tested and subjected to cross-examination and scrutiny, just like any other person accused of a crime. So I think we have to be careful when we just say the college is doing all these things wrong and they're covering up as they always have. I don't think that they're doing that, and they've shown it. And a good example is an organization that they started called AGREE, which is the Advisory Group for Regulatory Excellence. And they've got the major colleges involved, and their number one issue they're addressing is transparency, how to make public access to information more accessible.
I'm glad you raised transparency, because we live in a time where there is a demand for and expectation of more transparency. And I think the point that Michael is trying to raise is that there isn't transparency enough, at least in terms of what the public wants. For the patient that goes and complains to the college, that they feel victimized and then re-victimized about being left out of this entire process, and then some doctors left to go practice again in a lot of cases. I mean, is that not a fair point, that there is a call for more transparency in the college? Jeremy, you start here.
Yeah, I mean, I think there's no doubt that there's more transparency needed, but I wouldn't just single out the colleges for this. I think throughout healthcare there's a need for more transparency.
Because I should mention, many of the healthcare professions are self-regulated.
In fact, yeah, I believe there's 23 regulatory colleges in Ontario, so that covers everything from psychologists to nurses, doctors, to nurses, etc. But it's not not, sorry, 21.
21, and then there are 5 new ones.
5 new ones. So but it's not even just the colleges and the health professions. It's throughout. It's hospitals, it's the government. None of us are transparent. Right now in healthcare, the default is confidentiality, and we're transparent only when we're pressured or when there's exceptional circumstances. And in my view, the default needs to shift so that the default is transparency, and then when it's appropriate, we keep certain information, obviously like patient information, confidential. And I really think that shift, it's beginning to happen, but there's a ton more work to do in the system.
Okay, how do we get to if that's a default? Do we agree that's a default, that we need more transparency?
That we move from saying everything is confidential to give me a good reason why something should not be public. And so that's a process. These, as been mentioned, we have these 6 colleges working together. We've worked up a set of principles for transparency, which includes privacy, which includes the proper understanding of what is useful to have, what's the risk of the information. So the college right now is making sure, and it's coming to council in December, to make certain things transparent right away, where criminal convictions, any bail conditions that a doctor is under that would affect their practice, to begin to put things that are public on the website so they can be seen. We're going to be considering cautions when the investigation committee does not refer to discipline but issues their own caution. Should that be public? Should the educational requirements at investigations be public? And those are coming through. They're going to be considered by council, but we don't just say that's what's going to happen. They go out for 3 to 4 months of public consultation, because one of the problems is to get it right. There are unintended consequences we want to avoid. Such as, you know, if I just think of a small town, does the complainant, how do we work out that what we put on the website about this case?
Meaning not to disclose our identity.
Not to disclose identity. So we have to work out what works best and gives information, and to find out through this consultation, is there something we're missing? So rather than just, you know, becoming the kings of the world and saying this is what we do, we public consult as part of transparency. And you'll see that a lot of that's happening now if you go to a website. There's nothing that isn't available for consultation.
Okay. Mark's laid out what the college is considering doing in terms of increasing transparency. I want all 3 of you to weigh in. Michael, we'll start with you and then go around the table. Is that enough?
Well, it's hard to know where it'll come out. The colleges started this initiative, for which I applaud them, a couple of years ago, and it's still, you know, in process. So it's a pretty slow-moving train from a public point of view. I mean, the groups that are looking for this, more transparency, are some pretty important groups. For example, the Ontario Hospital Association is quite concerned that the college can go through a disciplinary process, the first stage, and not inform the hospital. So the hospital may have a physician that has, you know, the college has investigated, and it's not about seriousness, it's about whether they think they can get a conviction. So we go back to your circumstance as an abused patient. A good reason that the college might think a conviction is unlikely and not refer is that there's no corroborating witness. It's a solo act, 2 people in a room. But the hospitals have their own processes, and to not let them at least know who they should maybe have a look at the earliest stage is a problem from their point of view, and they're on the record supporting Patients Canada's point of view, which is let's make this much more transparent. And I don't think hospitals are going to act irresponsibly. They have their own legal processes and accountabilities, but there are some cases where there were disciplinary actions within the college. Hospitals weren't told about them, and then they subsequently found that they were on the receiving end of criticism.
You mentioned groups. You've been in government. The government is concerned about this, again, looking at it now provincially. Let me come to you, Julia.
Yes, I just wanted to respond to one thing that Michael said, and then I wanted to speak to the issue of a caution. So with respect to the release of information to another agency, the college's hands are tied with the confidentiality provision in the RHPA. There's only certain people that they can disclose information about an ongoing investigation. So before the information is published on the record, you know, a hearing has been held, a finding's been made, a penalty given, They can't release it to everybody. So that would need to be a legislative change to allow for that.
Can I just stop in here and ask you what merits a caution? Can you give us some examples of what?
Okay, so now for the caution, which is a separate piece, because a caution occurs when there's been no finding of professional misconduct or impropriety. A caution occurs when a patient or someone complains to the college. The ICRC considers the matter, and they say, you know, it's a paper review. So they don't meet any people, they don't talk to the people, they don't test, you know, their credibility. They're reading letters submitted by both sides. And then they say, perhaps this person could have done better. This physician could have behaved better. They haven't, let's say they haven't spoken properly. Sometimes complaints come in that people are rude. Their doctor's rude to them. So let's say that the ICRC says, you know what, that's really unacceptable. So we're going to issue what's called an oral caution. And an oral caution is administered, and it's again, an attempt at remediating the
What's that,
professional.
like a rebuke? Like you shouldn't be rude anymore?
Yes.
Okay.
Exactly, so that they learn next time not to behave like that. And as someone who defends regulated professionals, I really object to that being ultimately recorded publicly on the register. That means you had a bad day, you know, you got some bad news at home, and let's say you're rude, you are cautioned.
Let's not use that example, because maybe that one's an easy one to say people had a bad day. But why shouldn't give me another example. Let's make this quote more serious. And we don't have to go the extremes of serious, but I'm looking for some middle of the road.
Take you know, the mishandling of a file, forgetting something, not ordering a test that required to be ordered, and the patient maybe having a negative outcome, or a subsequent physician saying, yeah, you really should have ordered this test.
Sure, okay.
Okay, which is maybe a better example, because we really need to, when we're talking about transparency, for who is the transparency directed? The public. Does the public need to know that information? That on this one occasion, or whatever, the doctor neglected to order the proper test and didn't handle the file, the patient, the way they should have. So if the caution is issued, ultimately what some of the colleges are talking about, I know the College of Physicians is going there. I know the Royal College of Dental Surgeons has already circulated its bylaws saying it's going to make cautions public. That means every time a caution is issued in the complaints committee, when you've had no testing of that allegation, the doctor will have issued against his or her name a public forever record that he or she was cautioned. And I think that's really unfair based on a he said, she said, without having a full hearing.
Okay, let me ask you one more question about these cautions. Is there follow-up from the college? So doctor gets rebuked or punished, told not to do it again, you screwed up on this file, make sure it doesn't happen again. Does the college follow up?
Sometimes, and Mark can speak to that.
I can speak to that. An oral caution is not just simply bringing someone in and saying, you know, you shouldn't talk rude or you should have ordered that test. It's looking at the seriousness of it and saying, along with that, we also expect you to do the following educational issues. We may follow it up with a peer assessment to follow if that's necessary. But this is not just a simple group of 5 people and that doctor talking to each other. There are consequences to try to make, again, to correct the situation. And I think those are very reasonable things to do. Should they be public? This is why we're going to consult on this. Come December, our December 5th, when we bring this kind of amendment up, as should oral cautions be published, I will assume for the moment that council will pass that for public consultation. And then we'll see, we'll get replies like Julia's, we'll get other people, Michael saying, you know, it ought to be up there, and then we'll go back and we'll go and see what's the best thing to do based on the replies we get. This is a area where we're trying to get the best physicians for the best patients that we can. And sometimes there is difficulty in knowing the answer, what's the right thing to do. So we err on the side of public protection. Doctors do educational
wait a minute,
courses.
Mark, because a lot of people would say you err on the side of protecting your 32,000, I think that's what you have, doctors. I mean, how do doctors feel about all of this?
How do doctors feel? They feel, you know,
they're a diverse group. I get that they
but
don't all feel the same.
if you ask the public, as you just said, the public worries, are we protecting doctors? And doctors worry, are we protecting the public and not them? This is a constant kind of tension. What everybody on that council who's been elected, appointed, is there for is to take care of the public, and sometimes the doctors aren't happy with what we do, but we know our direction.
Okay, Jeremy, let me come to you about something that Mark just said. How should the college address the perception, the public perception, that this college, on the ladder of hierarchies, is protecting its members rather than the public, no matter what it says? How do you deal with that?
Well, I think cautions actually might be a very good way to get at this. So there may be very good reasons, and I think we've heard some of them, why caution should remain confidential. But that doesn't mean that there doesn't need to be other transparency measures put in place so that the public can have confidence in the cautions process. So we could have independent audit of the complaint or the cautions process to make sure that that there's agreement that only more minor issues like have been described are going down the caution stream as opposed to going down the discipline stream. And right now, my understanding is that there's an ad hoc follow-up process that goes on with cautions, but that not all cautions have a mandatory follow-up process. And I think knowing that there was a mandatory follow-up process would help a lot. And there's also, my understanding, not necessarily an escalation for people for whom there are repeat cautions. That is the repeat offenders that Michael was making reference to earlier. And is there a way of looking at those repeat offenders to find out, well, is this a case where it maybe does need to go up to the disciplinary committee? And I think if some of those the issues were in place, or some of those provisions were in place, then I think the public could have more confidence that a confidential process was nonetheless that there was accountability and was being appropriately done.
Thanks. I just wanted to say, with respect to your comment that the public's perception is that all that the physicians do is protect their own. I can tell you, having defended doctors think that the college is out to get them. It's completely, there's this tension that exists, and it exists with all of the regulatory professions, that the public sees the doctors as protecting their own. The doctors see the college as coming after them. So, and having worked on all of the angles, I've seen all of it, but I don't see them protecting their own. I see that they can't, even if they wanted to, they can't based on the legislation that they operate under.
Michael. Let me go to Michael, and then I'll come to you, Mark.
Yeah, I come from a family of doctors, and you're exactly right. My brother, who's a family doctor, my late father, who was a surgeon, and his two brothers, they felt even a phone call from the college was, it was taken with great seriousness. They felt it was great criticism. There's no question that physicians feel, very set upon. I mean, they work very hard. The vast majority of them do their best. But let's separate between human nature and things that happen that are very human. Physician goes through a divorce, they're upset, maybe they're rude to a patient. Okay, I've got no problem with us treating all of that in a humane way. Where I have a problem is where you've got someone who in 1990 is before the discipline committee, sanctioned for sexual misconduct, back in 2010, sanctioned again, and then 2014 back again, and what's the sanction? He can no longer treat female patients. Well, think about that in any other context, and you would be laughed out of the room if you said, oh, this person has abused a large number of women. And I will say this because it took me a long time to come around to Mary Lou McPhedran's view. But I would say to any man who's listening to me saying, oh, it only happens occasionally, talk to your daughter, talk to your sister, talk to your spouse, and you will find out that there's a whole lot more going on, not doctors, but the whole society, of unwanted sexual attention to sexual abuse. It is not a small issue. It's the tip of a very large iceberg. And what upsets me is when you come down with discipline decisions that make no sense to the public.
You have to tell us who I know Mary Lou McPhedran. She's a lawyer. She pushed for women's rights for many.
Zero tolerance is what she pushed for. Yes.
Okay.
And back then I thought that was extreme. And 20 years later, we left the college a lot of wriggle room legislatively to deal sensibly and humanely. And that wriggle room has allowed, let me say it very directly, people who appear to be sexual predators to still practice medicine in this province. And that's wrong.
start with one thing. I just want to correct Michael. He talked about communication between hospitals and physicians, and as Julia has mentioned, there's laws that stop us from doing that. Right before the legislature now, and I think next week I'll be going to talk to a parliamentary committee about it, is there amendments to allow greater communication to occur, the kind of thing we need to have happen, but it takes a legislative process to make it happen. Again, I look at this case, and you know, I am outraged. I have started with the Assaulted Women's Helpline. I was a founder of it. I was on Women in Transition Board as president. I'm very aware of abusive situations, and I know that we have to move forward on this. But at the moment, this is a case from 1991. We can't go back in.
I mean, people are saying, take the guy's license away. Well, he shouldn't be allowed to practice in this province.
Julia will tell you there's process. This happened in 1991.
Well, how long do we let the process go on? Because in this process, it seems to me...
In this process, this doctor was sanctioned as he was in 1991. I can't walk in and just say, I've decided to take away your license now. There has to be an allegation.
But not for sexual abuse, Michael.
You have no idea what that was about.
That wasn't...
Well, I know, because you don't disclose it.
Is that Dr. Tadros?
Yes.
No, that wasn't sexual abuse. All of them.
Well, then why have you limited his license to only treating male patients?
No, I mean, ultimately it was. But you've listed the 3 dates, and not all 3 findings against him were with respect to sexual impropriety.
And that helped. First of all, the college is an enormously respected body. If any time in the last 20 years you had gone to the government and said, we want to share more information with hospitals to prevent harm to patients, that legislation would have gone through with all party support. So, you know, now that there's a minister pushing you, saying the public want more transparency, the public want more disclosure, suddenly it's an issue. But you know, when you've got self-regulation, and you say it in your own document, you say self-regulation is not a right, it's a privilege extended. Physicians have been granted the privilege of self-regulation. Society allows physicians to regulate themselves in return for a covenant that this regulation will occur in the public interest. How is it in the public interest that hospitals are not informed that physicians that are appointed by them have, you know, come before your disciplinary process?
You've been a politician, so you know.
I've never been a politician.
Okay, I've only got a couple of minutes, so Mark, you got to get in here, yeah.
Okay, I'll go real quick with this. That we have been asking for the rights to talk to hospitals for over 6 years. We have asked government one after another to do this. It is only now that this is happening. There was before the election, it was on the order paper, Bill 28, although I won't quote that, to hopefully get this. We started all over again now. Hopefully this goes through this time, and then we have a better chance to doing that. We've asked for a lot of things to increase transparency. Could we have been doing better 20 years ago? That's 20 years ago.
Well, could we be doing better today, I guess, is the question.
Yes, we can. And that's why we are putting these things out there to say this is what we want to do. But as you can see, there's argument even about should cautions be public? Is this in the best interest of patients? Is this in the best interest of better health care? I don't have the full answer myself. I'm the guy who runs the meeting. But they will go ahead and pass this. It will be consulted on, and we'll do the best we can. But we're not going to rush in and just say, this is the way we're doing it. That's the old way of doing it. We're going to consult.
Okay. I have to leave it there. Thank you all for being respectful in your disagreement and your debate. Appreciate it. Mark Gable from the College of Physicians and Surgeons of Ontario, Michael Decter of Patients Canada, Julia Martin, Health and Professional Regulatory Lawyer, and Jeremy Petch of HealthyDebate.ca.
Support Ontario's public television. Donate at tvo.org.